Good morning, everyone. Our virtual participants and our participants who are present in the hearing room, thank you so much for participating in the Commission's formal review of its regulations pursuant to SC Code, South Carolina Code, annotated section 1-23-120J. If you recall, the clerk's office issued its initial notice of workshops related to basically, well, not all chapters, but most of the chapters of the Commission's regulations on December 1st. And the Commission staff's review of Article 8, which relates to practice and procedure regulations for the Commission, was included in that notice. The date of the workshop was scheduled for today, February 13, 2026 at 9 a.m. And then on February 4th at 11 o'clock, the clerk's office published, I wouldn't say an amended notice, but a notice that deals more specifically with today's workshop. And after reviewing the filings from you all as participants, felt the need to provide a list of issues that staff has talked about since our last review to get some feedback from you all, from the participants. In that notice, we mentioned today's workshop, the date and time again, but then also some other topics like electronic notices, whether the Commission's Regulation 103829 and motions needs to be clarified, the Commission's order related to Pro Hoc Vici, order number 2024-352, and whether the Commission staff should create a regulation for the Commissioner's review related to that Commission order. And then finally, a regulation to potentially address hearing examiners' ability to hear all types of cases. And I know the Commission recently amended the procedures for customer complaint proceedings, but just like your feedback on that last number 4 issue. And then, of course, if you have any other comments or regulations that you'd like for us to consider today, we will do that, okay? All right, so let's start with our participants. I'll start with Mr. Terraney. Mr. Terraney, are you here and present? Would you tell us if you're representing anyone at this time?
Yes, ma'am. Good morning.
Good morning.
I'm here on behalf of Nexus's South Carolina Water Utilities.
Thank you. And let's move next to the South Carolina Department of Consumer Affairs.
Good morning, Ms. Boyd. Roger Hall and Jake Edwards with the department.
Thank you so much for being here and participating. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Morning, Ms. Boyd. Lyle Trawick of Robinson Gray, outside counsel for the companies, and with me is Tekla Henderson.
Y'all let Mr. Wellborn off the hook today?
You know, can't be two places at once.
Oh, I got you. Okay. Palmetto Broadband Coalition.
Good morning, Jocelyn. Nanette Edwards on behalf of the PBC.
Good to see you. Dominion Energy South Carolina Incorporated.
Good morning. Elizabeth Hutton with Dominion Energy South Carolina, and with me today is Michael Anselmo from McGuire Woods.
Thank you, Ms. Hutton and Mr. Anselmo, for participating today. Piedmont Natural Gas Company Incorporated.
Good morning, Ms. Boyd. Jason Richardson of the law firm McGuire Woods here on behalf of Piedmont Natural Gas Company.
Thank you for being here and participating. Southern Environmental Law Center.
Yes, good morning, Jocelyn. This is Kate Mixon for Southern Environmental Law Center. I just wanted to say I'm feeling kind of under the weather today, so I'll be listening in, but if it's okay, we may follow up with written comments at a later time.
Okay, thank you. I hope you feel better. Last but not least, Office of Regulatory Staff.
Ben Mustian on behalf of ORS.
Thank you, Mr. Mustian. Okay, everyone. So, these workshops, I like to make sure that we feel comfortable with the way in which we proceed. And we can cover the first topic first if you would like, for example, electronic notices, and I can ask each of you your comments related to each agenda item from the February 4th notice, or you can provide all of your comments at once. So maybe it's easier though, Ms. Weed is recording this, maybe it will be easier to go item by item. I will tell you on the first item this morning as I was driving to work, something I would like for you all to consider. I don't know why it just dawned on me this morning, but if you may remember the commission held a rulemaking a couple of years ago related to protection of customer data. And there are certain standards, guidelines, not necessarily guidelines, but standards in that regulation 103.823.2. But each utility is required to has filed, I think, those guidelines that were approved by the commission. So I would like your feedback on that too, as you talk about item number 1. And the reason I say that is I know that this is not the first time that this issue has been, well, maybe it is the first time, but each utility, I would think, there may be some variation in how each utility provides those notices due to their current systems processes. So that dawned on me this morning. I know we're going to talk about cost and benefits, but I think part of the reason staff included this agenda item is, I don't like using the word transparency over and over, but that's the best word I have right now. So that if someone wants to know how company XYZ, how to access company XYZ's electronic notices, should the utility company XYZ's steps for accessing those notices be approved by the commission? And why do I say that? Because if I just look at our simple process with our docket management system, sometimes our process for, I don't want to say processing again, reviewing and processing a matter may change. Depending on the needs of, we may need to modify the docket management system. Now that's a simplified example compared to what utilities are responsible for doing. But I understand that systems can change. And so when that thought crossed my mind this morning, I said, well, there could be a point at which even if a regulation is created, there may be a need in the future for that process for that utility to change. So that's why I'd like for you to consider what was done in Regulation 103.823.2, which requires utilities to file those guidelines with the commission and the commissioners approve them. And it's should that those guidelines need to change, there is a record of them where anybody can access that information. Similarly, what my thinking was with notices, you may need to change, you may need to make modifications in your systems or procedures. We do with our docket management system. As I said, that's a simplified example. So I just wanted you to kind of think about that if you don't mind. All right. Does anybody have a problem with us issue by issue? I don't think some will take as long as others, perhaps. All right. So we'll start with Mr. Toraney. Mr. Toraney, do you have any thoughts on item number 1, which relates to procedures utilized by investor-owned utilities to provide electronic notices to customers?
Yes, but I want to be sure I'm commenting that I understood the topic that was noticed. I took it to ask for comments on whether or not electronic notices were effective and should be used or required. Were you looking for something else, or did I understand this correctly?
Okay. Live stream team, is there a way for us, I'm coming right back to you, Mr. Toraney, to increase
Sure.
Mr. Toraney's volume? Is it the air? Okay, can we adjust the air, y'all? It's, that's where the event is over on that side of the room.
You need me to speak up?
No, sir. They're going to adjust the air. It's just
Okay.
the vent is over one, the air vent is over one part of the hearing room, and it is hard to hear over there.
Okay. I usually don't have trouble being heard.
No, your volume is just fine. Oh, here we
Okay.
go. Okay, yeah, it's going to take a second. Okay, thank you, Mr. Terani. So you asked, the air is off right now. You asked, I think you're asking me what's the purpose of this item.
Yeah.
Yeah. Okay. Okay. So we're wondering whether or not regulations should be promulgated to develop standards for electronic notices that are provided to customers.
Okay.
All right.
I took, and I can comment on that based
All right.
on what I've gotten from the company. We had initially understood this to be more of whether electronic notices should be used, but nonetheless, I think that makes sense. So, as to standards, I don't really know. I think it would be difficult for the commission to micromanage noticing, and I say this also in the backdrop of the fact that the Nexus utilities, perhaps unlike other utilities, are not as are not necessarily as wedded to electronic noticing as others. We would like electronic noticing to be optional. We our noticing system, our electronic noticing system involves an email which links to a web page or the My Utility Account portal that our customers have, depending on the type of notice. But typically, we've seen a low rate of adopters and response to electronic noticing. They are cost effective, obviously, because it doesn't cost nearly as much to send an email as it does to send a postcard. But the response rates aren't quite the same. Not all of our customers have signed up for it, obviously. If they haven't, we're quick to send by mail. We also use a QR code on electronic bills and on printed bills that people can use to access electronic information. Having said all this, I understand why the commission would be concerned that people aren't necessarily responding to their notices, but I don't know how I think it would be very difficult to put this into a regulation that would have any kind of enforcement or duration, because you may have great response on one email and not very good response on another. That could have to do with the time of year. And also, I mean, honestly, you can send the notice by U.S. mail and have poor response on a U.S. mail notice. So to look and say, well, we need to have standards on electronic notices, presumes something that may not be true, which is that the U.S. mail notices are more effective. And I'll just add one more thing. I have noticed in recent hearings, the commissioners seem to have been concerned about low response at public hearings. And not to turn this on y'all, but I wonder if one of the things that is suppressing attendance at public hearings is the sign-up procedure.
Okay.
Where people are being, and I know the commission allows anybody to speak if they show up, but people get this notice and they say, well, you need to sign up for the public hearing by X date.
Mm-hmm.
And I think maybe people go to these things a little more spontaneously.
Okay.
And I in other public hearings, say county council meetings, zoning meetings, HOA meetings, I never sign up 2 days in advance.
Okay.
I just kind of make up my mind to go or attend virtually at 6 p.m. But maybe if I've gotten this notice, I've kind of understood that it's a thing,
Mm-hmm.
and I've got to sign up for this thing. And if I didn't sign up for it, then I'm not going to go.
Yeah.
So I would just kind of offer that as an observation, and also let's do away with the newspaper notices. I mean, the newspapers are just, especially the state, I'll single them out, are charging extortionate rates for these notices, and nobody's reading them.
Okay, you gave me a lot to talk to you about. Thank you. And so, Mr. Rainey, as you know, the commission recently started the pre-registration process, and I think it was COVID.
Mm-hmm.
And you're the first person that I've spoken to say that. That's interesting. I don't think, I mean, staff is accustomed to, I am anyway, I've been employed by the commission long enough. I'm aware when the commission didn't didn't use pre-registration.
Exactly.
Yeah. That's something to think about. Thank you for that perspective on that. The commission is not advocating one way or the other for customers to attend. It's the notice is issued for those who want to attend. But that is a very interesting perspective.
But just to take it back to my clients, we would just like all this to be optional and not micromanaged.
So glad you brought up your client again. And I want to talk to the chair because that's something that we do have several. I think I counted yesterday. We have 10 outstanding customer public hearings after today that have been scheduled. But after that, and I'm sure all of those notices contain pre-registration, that option. But I think that's definitely something I need to talk to the chair about, whether or not the commission should reconsider that. All right, next thing. So something I want to ask you about. Do you know how your client and its customers converse about the electronic notice option? Is it just a part of the original, or is it like one of the places where I bank? I'm still old fashioned. I want my paper notices, but they'll keep sending reminders. Is that do you know how your client informs customers? You have this option if you want to receive notices electronically. Do you have any idea?
No, it's on the web page.
Okay.
I would have to ask about the rest. I don't know.
Okay. I'm just curious. And
we'll be glad to follow up on that. I don't know the answer.
I was just curious, and then the company, your client may send notices. Are the customers aware that notices that are issued by the Public Service Commission are included in those notices?
I'm not sure I understand that question.
Well,
you mean if they sign up for electronic notices,
yes,
do
sir.
they know?
That will include potential, not just rate adjustment, it could be transfer of assets, anything where the customer may need to be notified, but it's a notice is issued by the commission. Do you know? Right. I'm just curious about the customer's perspective,
I assume that if you sign up for paperless billing, you assume that whatever communications are going to come by email. I don't know that we've explicitly, I'll have to check. I don't know if we explicitly say, hey, you're going to get your PSC notices this way, because that's not necessarily true.
That's true.
I mean, we're required to mail notices all the time.
So you
I think
still
in all of our rate cases, we're mailing notices.
you mail all of yours? Okay. I was just curious.
Well,
And then
that's been a commission requirement.
yes, sir. Yes, sir. And then I will also take back to the chair about the newspaper notices, because we want the most effective way of noticing. I think, yeah, we'll look at that issue. Okay.
I'll stick up for the Post and Courier here. They're pretty good about it, but the state.
Okay. Yes, sir.
Ms. Boyd, could I ask a question? I'm not sure I'm following this point about published notice. Is
the newspaper notice?
Are what you're suggesting taking back to the chair to do away with that requirement?
No, I was just not necessarily do away with it, because we
You know-
wouldn't do that unilaterally.
Sorry,
just Mr. Terrani's thoughts.
Okay. The only reason I was confused is it's the only statutorily required notice issued by the General Assembly. It's in the APA. That's the only mandated method of notice to customers. So I don't think you can just get rid of it.
Okay.
I'll talk more in my comments, but I just wanted to make sure I was following what notice we were talking about here.
And I'll just add, that's not always the case that these notices are statutorily mandated, but we're talking about electronic notices anyway, so I just threw that in.
Okay. All right, Mr. Terrani, I'll come back to you for the next topic on motions, if that's okay. I'll return. All right, thank you. So next, Mr. Hall and Mr. Edwards.
Thank you, Ms. Boyd.
Yeah.
We have a few comments on this issue. Our main concern is mostly with rate cases. We asked customers at the public hearings for Duke's rate cases how they heard about that public hearing, and we got a wide array of answers, and it would generally be nonprofits, newspapers, social media, and the bill did not seem to be the primary vector of awareness, or bill insert is more accurate. And we have concerns that the customers receiving electronic notices are less likely to see that there is a public hearing for their rate case. And we also have concerns that this might be impacting turnout within certain demographics, like for instance, the younger demographic, people my age and younger really aren't at these rate case hearings. And we do have suggestions and possible ways to consider, because, I mean, Roger and I, not to pick on Dominion here, but as customers of Dominion, we have access and can try and find our rate case notice, and we noticed it took a few scrolls and clicks to get to the actual notice of the rate case and rate increase. And we would suggest that the commission consider possibly sending some automated texts, or having the utilities sending automated texts, similar to what they do for like a power outage, which I personally find very helpful when I get the text about power outage and restoration efforts. And we think that could increase just awareness and is more likely to see, especially if the customer's opted into text notices. And we think this could even provide links, say, to the sign-up sheet if there is still a sign-up process. Though I do agree with some of the spontaneity that Charlie was mentioning. I do think some customers choose just to show up day of.
Do you think that might be a deterrent, the language in the notice about pre-registration?
Yeah, you know, Justin, I hadn't thought about it. Y'all brought it up. And I think in some of the past workshops, we've mentioned that there's this registration requirement, but then it's not really a requirement, right?
Right.
Y'all still let them show up.
Yes.
And I was thinking about what Charlie said. Yeah, I think I agree that maybe doesn't need to be a requirement, but maybe keep it so if, like, say folks like you're going to take those who registered first, so that way, hey, I want to register so I can get in and get out, kind of thing, you know, and if you know I have other things going on. So that was my only thought, is maybe say if you register, you'll be called first, but it's not a requirement. That's just again from 5 minutes ago hearing Charlie say that.
Do we need to include larger text that says pre-registration is optional?
I don't have the current language in front of me, so I mean, it may need to be, if you choose to register, those who choose to register will be called first.
Yeah, we say something like that already.
Do you? Okay.
Mm-hmm.
Yeah, so maybe just say it's not, maybe then just say it's optional. Like
optional. Okay, I don't know what he's going to say. This is procedural, everybody, so, you know, I don't think anybody's due process rights would be offended if I talk to the chair about just the pre-registration process, as I said, because it's not always existed, as several of you probably know. But okay, I'm sorry, Mr. Edwards.
No, all good. I would just like to also add that we think, you could also probably solve this with just more prominence, maybe a specific email for just rate increase cases and notices, or just maybe an alert icon on the website that is prominent enough where customers will see it when they're paying their bill, and not something where they have to scroll or really have multiple clicks to try and get through to somewhere.
All right, so either specific emails to customers or link on the utilities homepage to the notice? Is that what you're kind of thinking?
On the bill or on the billing page where I pay, I don't generally open my bill, but yeah, on the account page.
On the account page.
And then we would also recommend, if possible, that the commission consider, with the upcoming candidates public night hearings, just having a simple questionnaire for some of the customers that show up and just asking how they heard about it, just to collect more data on the issue.
Anonymous questionnaire?
Yes, ma'am.
Or really, Jocelyn, folks have to sign in.
Mm-hmm.
So that maybe just next to that, how did you hear about this?
Okay, so a column. Okay, simple anonymous. Or a column on sign-in sheet. We need them to check a box, probably, or they'll be standing there writing all day. So, okay.
And then I would just like to add that we think our comments with the automated text, we think that they should be considered pretty much solely for larger utilities.
Mm-hmm.
For smaller utilities, we think it might end up being a bit of a hassle, or they might not have the system available.
What's the number of customers? That's kind of the standard in the code, right? You have 100,000 or less?
Yeah, General Electric is what we were thinking.
Okay. All right. Okay. The automated text for larger utilities, pre-registration is optional. Perhaps consider specific emails to customers that contain the link to the bill, to the notice. Link on the billing page where payment is made, the account page. The link is for the notice, and then simple anonymous questionnaire, or add a column on our sign-in sheet. How did you find out about today's hearing? Okay. All right. Moving on. Thank you very much. We're going to move now to Mr. Treywick.
Good morning, Ms. Boyd.
Good morning.
A lot to take in here from the comments so far. I do want to start with the notice, and I pulled one up for instance, for now.
Which one are you looking at? Because
I'm looking at the hot off the press one for the additional hearing for the Anderson CC.
All right, 250.
And it says that customers who wish to testify in this hearing may pre-register in one of three ways. The commission will call the names of those persons who pre-register to testify first. So I think that's already sufficiently clear. And I agree with Roger's comments that, obviously you can have walk-ins, but this is just making clear that, if you register first, you will get called first. So you sort of have that certainty. If you come in, you can do that. So I don't think that needs any changing. I feel like that's pretty clear. And from the company's perspective, particularly in rate cases, having that pre-registration list is extremely helpful and invaluable, because we bring our customer service representatives there. And if we already know, for instance, that certain customers are coming, we can look into their account issues and have someone there to hopefully satisfy whatever concerns or bill related issues they may have on the spot.
Okay.
And so we see a lot of value in that.
Okay.
And that's why we bring folks, the right folks from the company to the rate case public hearings for that specific purpose. And so that's really helpful to us on the front end. And so we think pre-registration should continue. We don't think it's scaring people off, for instance, because I feel like the language in that notice is pretty clear with the may, and then you just get quicker in line than if you show up.
Yeah.
So appreciate that. In terms of regulating how electronic notices are sent, we're still thinking through and trying to gather the information with respect to the questions that were in the notice. But we don't think that should be regulated. That does smell a little bit like managing the utility. I think for a lot of good reasons, the commission, has the regulation on protecting customer data. But there's necessarily going to be a lot of differences among the utilities in how they communicate with customers. And so we just would respectfully request some flexibility there. I can share that the companies, for those who have elected to have paperless billing, when they get their bill message for the month, there's a link that goes directly to the page with all the bill inserts and on the web page. And then there is a separate page on Duke's website. And whenever you visit there, it knows, I guess, generally your location, and it will have the right jurisdiction up there, right? So if you're, for instance, in the PD, you'll have DEP South Carolina will sort of be your default. And so when you go to the bill inserts, the DEP South Carolina ones will show up. But you can also go to the drop down and change your jurisdiction if you're interested in something else. So in terms of the push notifications, we did, and text messages, we did sort of explore that with our billing folks. And the concern there is that our customers have really become accustomed to and been conditioned to only receive notices in really important situations like emergencies, like your power's about to go out or your power's about to come back, and storms and things of that nature. So, when you think about all the push notifications we receive on our phones, we wouldn't want them to then begin ignoring those because they're getting peppered with lots of public hearings that they may or may not have interest in. That's not to say that we don't see value in hearing from our customers in these public hearings, and we take them seriously. But the company does want to reserve those, sort of push notifications or text messages for the more emergent weather-related or service-related issues to not kind of jumble those up. In terms of newspaper notices, I agree they have gotten costly, but it seems like they are more of a statutory requirement. I think another reason to maintain flexibility is, again, not all of our customers have elected the paperless billing option. And so they do receive those paper bills, and so they get the paper bill inserts. It's my understanding that as part of service, we don't request an email address. So I don't know that emails are really feasible, or requiring emails, or promulgating standards across utilities for you to send emails would necessarily be feasible, because that's not part of the setup process. So I think just with all the unique features of each utility and how they decide to push things on a web or publish things on a website to communicate with customers, I don't think a one-size-fits-all really makes sense here. Now, there are certain situations, and we've advocated for certain situations in which a rulemaking is necessary, and let's get all the utilities there to look at standards, but we just don't feel like this is one of them. Happy to discuss other ways, but those are sort of our initial comments. And, if you want some more concrete information, we'd like the opportunity maybe after today, after hearing everybody's thoughts and sort of more what the why is, the opportunity to write written comments. But the last thing I would ask for is just with those, what are we trying to solve for? Public participation. There are so many ways for folks to become aware of these things. You're getting newspaper notice, bill inserts, online, and some people put it on social media. You've got a lot of nonprofit interveners who publish it via social media and direct outreach, and so there are a lot of ways for folks to become aware of this. And sometimes it just depends on their desire to show up or not. So we can't necessarily solve for every situation in which there's not necessarily a big showing at one of these things. But again, we appreciate and underscore the importance of public input, but don't think we need a regulation for everything.
Oh yeah. I think this is, well, there's some information in a docket. I can't remember which one, where the commissioners asked ORS to look into the issue, and ORS filed a report. I would say that, coupled with just some comments that someone mentioned, that I think the commissioners have heard at customer public hearings about a customer's receipt of the notice, And I think that I wouldn't even say a concern, but a question about, okay, well, if it's an electronic notice, what is required for the customer to access that notice? How easy is it for the customer to access the notice?
So whenever someone gets the paperless bill, if they've signed up for paperless billing at Duke, there's a link right there. It says click here. If there's a bill insert, and they click through, and it goes to the page. And
then that's on the page where the customer pays too. Did you just say that? I was trying to. Is that
no? It links you to the page where bill inserts are with the notices.
Yeah. But I mean, on the page where the link is to the bill inserts, is that on the page where the customer pays?
Yes, I believe so.
It is. Okay.
And I would also note, for transparency's sake, have left all the public notices up on that bill insert page for South Carolina. Okay. So you can go back and look and see to like 2021, I think. So the last 5 or so years has all the bill inserts listed on there.
Okay, and you like the pre-registration process?
I do. I really just think it's helpful for all involved to know who's coming and try to at least, look into their issues on the front end. And then also, we've raised before, I mean, unfortunately, this is a fact of life. I think security can be important there too. Some concerns the utilities have had based on prior experience. I'll leave it at that.
Okay. Thank you.
Thank you.
Ms. Edwards?
Good morning. When we were looking at the procedures utilized by investor-owned utilities for electronic notices, candidly, we were thinking this was aimed at rate-regulated utilities more than the rural telephone companies. Yes, but I did bring it up, and certainly there has been a move to do more electronically, and yes, it is less costly. And Charlie brought this up, I asked the question, well, to the extent this were to be mandatory, I polled and definitely we do not have email addresses. Even in telecom broadband, you would think we don't have 100% of our members. If you're a telephone cooperative or, if you're a telephone company, we don't have 100% email addresses. I think some of it is the demographics and the geography of where we serve. We still have customers that want paper bills. We do try and encourage electronic notices and electronic billing, but there are some that they want their paper bill. The FCC has made some recent moves. We are heavily regulated by the Federal Communications Commission. As you know, on CP&I, that is a big area. In fact, we're not under 823 because of the level of regulation about customer proprietary network information. So we're not under 823.
Okay.
What I was going to mention is that the FCC in their most recent orders has started allowing more use of our website, where we have to do certain required notices, in particular to not so much the retail customers, but when we're coordinating with other carriers, they're starting to allow more and more of notices via our website. But
may I interrupt you
sure.
right there? So just is the FCC's requirement for those type notices, is it just do they tell you the format?
Yes.
Disc.
I'll give you the exact example. So one of the more recent orders is the discontinuance of copper. We're almost at, DSL copper has really gone to the wayside. So there's two types of notices. The notices to your end user customer, hey, we now have fiber in your area, but there are certain attributes of copper. You could have power go out and you could still make a landline call.
Okay.
But with copper going away, there's certain, it's becoming, they want to encourage the upgrade
Mhm.
in the facilities,
Okay.
right, to
Right.
fiber. So we're now allowed to do more at the FCC level, and when my clients don't have this, they don't have resellers on their system, but the FCC is now also allowing notices on the website for discontinuance when you're going to move off of the older technology. So those are two areas in particular that I'm more recently aware of. I do agree with both Mr. Trini and with Lyle. Regulating the standards of electronic notice does sound like it would be very difficult, especially if you tried to do it uniform
Right.
across all the different types of utilities. Candidly, I have a diverse set of members. So how many of them have certain types of push notifications versus email versus what they're doing with their website? It would be a little bit unwieldy for us, and we tend to be small. We're smaller. We're definitely under 100,000. So I say all that to say we may have misunderstood the where you were trying to go.
Yes, I apologize for that.
No. Well, that was on us. My folks would say that stay optional while we are progressing and made headway in doing more electronically. We're not there 100% yet either.
And everyone, the for item number 1, 2, it's it would not. The intent is not for it to be a requirement, but if a utility does use electronic notices, basically, what should the standard be? Or standards be? That's really where we were going. And I think several of you have mentioned that it would be difficult to have 1 or 2 standards because it depends on the utilities. Systems is the best word I have right now, potentially. But one other question I was going to ask you about the FCC notices, Ms. Edwards. I know this may seem simple, but does the FCC state that the notice has to be at a particular place on the page? Does it have to be a certain font, color, anything like that? Or just...
Let me go back and check. I know, like the discontinuance notices, you have to have certain information contained in the discontinuance notice. I don't know if they get down to the type size. I'd have to go back and take another look. But I'd be happy to do that and come back to you with more information on that. And again, we've just noticed that the FCC, they're trying to clean up their regulations. They have the delete docket, and they do seem to be trying to push I guess what I would call more efficient, expedient way of getting out information and notices. That seems to be the most recent trend.
Okay. Thank you. Mr. Anselmo?
Thanks, Jocelyn.
Yes.
Like Duke, Dominion really does appreciate customer feedback. It helps in whatever format we get it. So I preface my comments with that. Let me start by saying we joined Duke in having pre-registration lists for the exact reasons Lyle mentioned. I won't repeat those. They are important.
Okay.
But as for the concept we're discussing today, I think you already probably know what I'm going to say. The law requires published notice in a newspaper. That is what the law requires. Electronic notices is optional currently under the regs 103.817 C3A. It's optional. So what that means is electronic notice is actually not notice under the law at the moment. This is basically a courtesy type thing. So when you start imposing standards on an optional courtesy, it is in fact counterintuitive. It becomes a mandatory requirement, right? So I struggle to see how imposing standards on an optional process benefits anyone, the utility or the customer, frankly. We all do it differently, as everybody's talked about. So another point is similar to Duke's, and 3A, the report you referenced from ORS. Dominion's
Yes.
process is in there.
Yes.
I'm not going to describe it. It's very robust. The short takeaway is it's easy to click the link. It takes you to a page that's always up on our website. In fact, I have it up right now. Every billing insert until 2023 is currently on there. It takes you right there.
Is yours is Dominion's on the billing page too?
Yes, it's on the insert.
Okay.
And then but the text idea, DCA, I understand the intent behind that, but it's not easy. And I'm going to highlight one thing that makes that hard. First of all, it's optional for our customers. So we're talking a subset of a subset of a subset.
Mm-hmm.
People who like electronic communications don't necessarily want to opt into the text messaging, right? So we're shrinking the universe even further of customers that get it. Then you also have federal statutes that limit what type of automated communications customers or people can receive. The Telephone Communications Privacy Act. I've been unfortunate to litigate a lot of that. It is draconian and costly penalties if you mess up. Emergency notices are exempted. I doubt seriously that notices of hearings would be exempted from the TCPA. It's something you got to consider here. All I'm saying is there is more complexity to text communications than simply convenience to customers.
Mr. Enzo, I'm asking, you said TCPA. Spell that out.
Yeah, T as in telephone, C as in consumer, P as in privacy, A as in act.
Okay.
It's a heck of a read. It'll take you some time to go through it, but it's every text, automated call or text is a monetary penalty to the person sending it, and it adds up quickly, as some people know who've received settlements in that regard, not from Dominion, but from other clients of mine. And then, again, I understand the need for transparency. I think the process is outlined in 2025-83A for Dominion show that we're doing it in a transparent and effective manner. And there's no other easy way to say this other than regulations don't change customer behavior. They're not subject to the regulations. We've struggled for years and years and years at this commission and elsewhere on increasing customer participation. I think that's a function of customer behavior, not the excellent efforts from the commission and the parties to notice the proceedings. So this is a very Michael Anselmo way of saying we don't need a reg on this area that's already optional under the rules. We like doing it, but I think we do it in a way that's effective already.
Okay. Let's see. Did we ask? Oh, you've already answered my original question. You answered the question related to, or not question, but provided feedback on the newspaper notices. And you said you like pre-registration. Okay. Mm-hmm. Thank you, Mr. Anselmo.
Sure.
Mr. Richardson?
Thank you, Jocelyn. Also want to echo the comments of the Duke companies as well as Dominion Energy as well too. Piggybacking a little bit on what Mr. Anselmo said about TCPA issues, as someone who's also had the pleasure of litigating those, for those of y'all that are extremely bored, check your Westlaw filings around every election and see how those just ramp up and how folks will take any opportunity they can to maybe litigate those issues and how expensive it can be to settle. So, I think the end idea here is that we don't want to box anybody in and potentially create or promulgate any regulation that could narrow flexibility for the utilities. But I know our Piedmont would certainly appreciate the opportunity to provide further comments and investigate these issues further. But, those are some top line things that come to mind. So,
thank you. Okay, Ms. Mixon? I understand that you may have and if you don't want me to call on you again until you can let me know.
Yes, thanks, Jocelyn. Nothing at this time, and we'll as I mentioned, follow up after
Okay.
after the hearing. So no need to call on me. Thank you.
Okay, no problem. And then Mr. Mustian.
Yeah, thanks, Jocelyn. Yeah, so you mentioned the report that we filed.
Yeah.
So that was in docket 2005-83A, the
Yes.
administrative docket that we filed back in, I think it was September of 24, when we had a different executive director at the time. But so, a couple things. I think generally speaking, some of the things that we noted in that, the different utilities have different ways of doing things. There are some utilities, I think, send just a direct link to the notices. Some may send a PDF. Some may not do electronic notices at all. There are some, I think what we saw or what we gleaned from the information was the fewer clicks that a customer has to do to get to the notice, the easier it is for them to see those. A couple things, whether there may be a separate email as opposed to including it as a link on a bill, electronic bill notice. I do know that I think the commission, I think DCA, when they've asked customers about how they hear about night hearings, a lot of people will say they've heard about it on Facebook from their friends or different community pages. So that may be something the commission wants to look at. But I think generally speaking, the less clicks, the easier it is for customers to access, the better. And I understand the concern about having a regulation that sets forth specific requirements across the board. That may be difficult to implement, and to the extent there are changes needed, that may become cumbersome. It could be as simple as if a company wants to use electronic notice, then they could ask the commission for approval of a process that could then be easily amended as need be. So, I think there's a variety of different ways to look at it, but generally speaking, I think kind of reflected in what our report was in 24, those are the comments that we have right now.
Okay, so thank you. I think this is the commission's, as a body, well, I say body because they're the commissioners, but as a whole, basically, this is our first discussion publicly regarding the Office of Regulatory Staff's report. Thank you for doing that work. And I hear you, and I've written down your position on the difficulty that will arise trying to regulate or create a regulation that suits the processes of all utilities right now. But you said one other thing, it wasn't exactly guidelines, but perhaps if a utility wants to, or if a utility uses electronic notices or publishes electronic notices, that perhaps their procedures can be filed with the commission? Or I'm not trying to put words in your mouth.
No, and I don't know that may be overly cumbersome too. It just occurred to me. I'm trying to think. I was thinking there was a similar docket or procedure along those lines, but essentially, letting the commission know, hey, here's how we do it, and yes, give parties opportunity to talk about specific procedures if there are ways to simplify it, and certainly don't want to create new docket unnecessarily, and but that could be one way to avoid the establishing a regulation for all utilities when each utility obviously is going to have its own procedures and processes.
So one other thing, though, because you did a lot of work on your report, maybe what do you think about this, using the research from the Office of Regulatory Staff's report? But I don't remember. I can't remember, Mr. Mustian, if you mentioned with specificity each utility's, like each utility that you actually surveyed, or I don't want to use investigated, audited maybe, or is that already a part of your report? And can the commission, with the information it already has, include that somewhere?
So just to talk about the report generally, so when we did the report, we focused on the electric utilities, Piedmont, Dominion Gas, and then the Class A water and sewer utilities. So Blue
Okay.
Granite and I think Defusky Islands, South Carolina water utilities. So, and I think in that report we talk about, number one, we included the discovery responses, so that outlines some of that information. We also talked about the different processes, so examination of procedures. We talked about customer serve, paperless billing customers, notices sent electronically for each of those entities, the steps required. We have a table, table 3,
Yes, right here.
that provides some high-level steps to access required notice. And and I will say this is it's been, I guess, a year and a half. Time flies. So I don't know if those processes are still in place or not, but and the different numbers of notices and those types of things. So that obviously the reason we didn't go into Class B and Class C utilities is because there are so many, and it would have been pretty cumbersome, I think, to look at all utilities. So that's why we focused in on those. And I think those were the utilities that are more likely to do electronic notice.
So I have it, Miss Purvis. Will you display what I have on the desktop? It's from the Office of Regulatory Staff's report. It's on it's table 3. So I like using what you already have. It's the way I was reared. What if Mr. Mushton, the commission, because the commission already has this information, if we reached out in a appropriate way to these utilities that are listed here in table 3 and asked them, is this still the current process? And if so, what can staff do on its websites to provide this information to the public?
Well, I think my initial response would be I certainly wouldn't have any problem with that. I would say I think all of these parties are here today.
Yeah.
Or representatives of these parties. And I, not to speak for them, I think they've kind of outlined all of these different things. So I certainly have no problem with that. I just I don't know what additional information you might get.
Sure. We can ask them, but I thought maybe I never thought about us using what we already have as an agency to not notify, but to share with the public. And then you mentioned our social media. I know that Mr. Botman uses that, and Mr. Hall and Mr. Edwards, he's really been using Nextdoor. So he took your advice seriously. He just sent one while we were working together the other day and sent the notice via Nextdoor. And I told him, select the whole entire state. Don't just, I can tell you which case it was. Just select the entire state. So we are using, he doesn't use Instagram as much, but he does use Facebook and Nextdoor. And Rob, if you're listening, let me know if I've missed somebody else that you use, some other platform that you use. Rob Botman. Okay, I think those were thank you, Mr. Mushton. Now, I'll quickly go and see, I'll ask if, yes. Is that Ms. Mixon? Oh, Mr. Taraney, I was going to come back to you. I was going to come back and ask real quickly if anybody had any follow-up statements. Mr. Taraney?
Just one.
Yes, sir.
I just wanted to call your attention to the fact that the notice procedures for the utilities are different statutorily, and that's something to keep in mind. In Chapter 5, which applies to water,
yes, sir,
sewer, and gas,
yes, sir,
the notice of rate schedule procedure is 585240B that says after a schedule has been filed, the commission shall, after notice to the public, such as the commission may prescribe, hold a public hearing concerning the lawfulness of the charges. So the commission has a lot of discretion with regard to water and wastewater utilities as to the form of notice. I'm not sure about other utilities. I'll leave it to them.
Thank you, Mr. Taraney. Are you okay right now? Okay. Thank you, Ms. Wheat. Oh, Mr. Taraney, anything else before we move to number 2? I'll come back to you in just a second.
No, ma'am.
All right. I'm just going to go around the room and hear y'all. Mr. Richardson, anything else right now?
No, ma'am.
Mr. Anselmo? Okay. Mr. Treywick? Mr. Hall?
I actually just had one question for Michael.
Okay.
What's the citation, or where are you referring to for requiring newspaper publication?
It's in the APA. I don't know off the top of my head. It's 123 something or other.
But so is that for rulemaking, or you're saying for anything agencies do?
It's all entities subject to in contested cases. You're subject to the APA. Right. It's published notice.
Yeah,
I can't remember the off the top of my head.
I didn't remember it saying newspaper specifically.
Well,
that's why I was asking.
We can look at it.
Yeah, we'll look later. I was on my phone. It's kind of difficult, but I will say, I mean, I was going to point out one of the statute Charlie talked about too, and not that it's anyone's fault, but in the APA, I'm guessing is like this too. It's probably not been updated in a long time. Mm-hmm. You see notice. I mean, one of the 58.5. There's another one 260 that requires the commission to give notice. And by publication. I mean, it hasn't been updated since 1962. Mm-hmm. So, I mean, I think publication and publishing, unless it's specific, like Michael's saying, for newspaper, can mean a lot of things in 2026. But other than that, I think just do appreciate the discussion. I will say I'd reiterate not to pick on Dominion, but just that's the only one I can access. It's more clicks than even showed on that ORS report. I mean, they don't have to have provided notice yet for the rate case that just got filed, but when we checked yesterday, there's nothing alerting me. It's not even the first message on my homepage. The first message was my meter reading coming up, and then I had to click into more notices, and then I had to know that it was a bill insert versus something else. There's 12 options on the page. So I just think, as Jake said earlier, that it can just be more prominent. Like you have an alert, you have something, it's a rate case filing, it's whatever it is. I mean, we're familiar with these topics, and it still took us a while to find it on our Dominion pages. And it sounded like from what Lyle said, maybe Duke's was a little bit easier, but again, I don't have a Duke account, so I can't access it. So overall, our message is to make it easier for folks to find these things.
Okay, and then I wanted to ask you too about, I asked Ms. Edwards about the FCC's requirements on websites. Do you have any thoughts about? And Mr. Edwards may have said, let me look back at his notes. Do you have any thoughts about publishing on a website? I mean, not as the sole way of notifying customers, but do you have any thoughts about publishing the notice or link to the notice on the homepage of the company's website?
I think is anyways to make it easier. I know, at least I know Duke has in the past for rate cases, has put out on their website at least has information about the rate filings and fairly prominent, whether it was a press release or whatever it was. I'm not sure about Dominion, but
Jocelyn.
Yes, ma'am.
I thought of another good example.
Okay.
Broadband labels. All of our it's industry wide. The FCC does require that if you're your broadband products that there be broadband labels. And so, I mean, if you go to anybody, AT&T, Spectrum, one of my clients, so the FCC is using the provider's website as a mechanism. Now, to your point, is it always the sole mechanism of notice? Maybe not. I'll go back and pull the The reason the discontinuance is on my mind is because obviously we've had this huge fiber rollout, and so copper's going to the wayside. So that one's top of mind.
Okay.
But just wanted to give you that other example.
Thank you. Okay, Mr. Mushroom, you don't have anything else? Okay, great. All right, everybody. Mr. Terraini, may I go back to you? Do you have any thoughts about our regulation 103829, which is motions?
I think it's clear.
You think? Oh, it's clear. You don't think that someone may think that they have the option to wait on the commission to schedule oral arguments before they respond to a motion in B?
I never have. No. I mean, the commission doesn't have to schedule oral arguments on a motion. I just always thought it was clear. I mean,
okay.
I understand the motion could land on the first day of the hearing, or the response could land on the first day of the hearing, the way things are currently. But I mean, if the commission wants to change that, you can change it. And usually if there are going to be arguments, somebody's going to ask for them, or the commission's going to tell the parties. I think that would be helpful if the commission, but I don't think you need a regulation for that.
Okay. Okay. All right. Thank you. If y'all don't mind, I'm just going to go around the room like this. Mr. Richardson, it's easier than.
Yeah, certainly. Yeah, I mean, I agree. I think it's pretty clear. I
Okay.
mean, certainly more direction you get for those of us that practice in state court, where you might get one at 12:07 the night before the hearing.
Mhm.
So, yeah, or somebody comes and hands it to you while you're sitting there. So, so yeah, I think it's probably fine as is.
Okay. All right. Mr. Anselmo.
I think it's crystal clear. No, in all seriousness, I've always read it to be what happens when you have written motions filed in advance of the hearing. B is sort of the procedure, what happens at the hearing.
At the hearing. Okay.
If there is a desire to make a change here, and I'm not saying there should be, one thing that's kind of logical is if you file the motion 10 days before the hearing, the response is due the day of the hearing. A reply is technically due 5 days after.
Yeah.
I mean, if you have a one-day hearing, it's kind of a waste. I mean, you could bump from 10 to 15, and that way everybody gets their papers in before the hearing. But again, I don't think that's needed. But otherwise, the rule is rather clear.
Okay. Mr. Treywood?
I think it's clear too. So what was the question? I just want to make sure.
So
I'm
the
answering
question is, for example, in A, the time frame to respond to motions is listed, and then in B, it says that the commission may entertain oral argument. So, and that those arguments are made at the beginning of the hearing. Could someone reading that and maybe not as familiar with practice over at the commission think that, okay, well, I don't have to rely on the response time in A because there is a hearing that's scheduled, or if not a hearing, I can wait until the commission schedules an oral argument to respond. And maybe thinking that, and instead the commission, the time elapsed that's included in A, the 10 days plus the 5 days, and then the commission makes a decision at a commission business meeting instead of scheduling an oral argument. I'm just trying to eliminate any confusion about the process in A or B about responding to a motion.
Got it. Yeah, I still think it's pretty clear. And I get that maybe you're trying to solve for folks who aren't in this room who aren't familiar with that practice. But I mean, unless that's been a problem, I don't know that we need to fix anything. It seems pretty clear to me. And I do like the discretion in there that the commission can alter the timeframes, enlarge or shorten for good cause shown. I think that's good flexibility in light of the procedural schedules. Some of these things operate on statutory timelines and they necessarily have to move quicker, and so you can't always get the 10 days before. And so, the parties can work together and propose timelines or ask for more time, less time, whatever. But I like the flexibility.
Okay, thank you. Okay, you want to speak, Mr. Edwards, on that one?
Yes, ma'am. We don't find the language confusing.
Okay.
We do just want to point out that 103-829A requires motions to be filed at least 10 days prior to hearings.
Yeah.
And just based on certain schedules, for example, I'm going to use the Dominion rate case as an example. The surrebuttal testimony deadline is May 5th, 2026, and the hearing starts 7 days later on May 12th, 2026. So, for example, if Dominion wanted to file a motion to strike surrebuttal, it would be impossible to file within 10 days of the hearing.
Yeah. So they could potentially have to make that motion at the hearing?
Yes, I could pre-file that motion today, I guess. You want me to?
Jocelyn, can I add one thing
Yeah.
there? So in recognition of that, again, on these cases that operate on more truncated timelines pursuant to statute, in our remarks on procedural schedules, the companies have been asking that requirement be waived. So that might be a good thing to think about on the front end when you're setting the procedural schedules, not necessarily having to put it on a single party, but just considering that and looking at those tight timelines where it's only, for instance, 7 days before, just to make sure that everybody can, file whatever they need to preserve the record.
So are you saying, help me. So in the pre-filed testimony letter, where
Yeah, so you know how y'all always solicit comments on procedural schedules.
Oh, the discovery
So when the companies have been filing those in these dockets that are, you know, move quicker, right? Like rate cases or fuel cases, for instance, what have you. You know, we've been asking that the commission waive that 10-day requirement on the front end, and that's been in the procedural schedule. So I'm not telling other people how to practice or how to do whatever, but I feel like that can be helpful to do it on the front end, so you don't find yourself in a procedural quagmire on the back end.
Okay, understood.
And Jocelyn, I would say, I think that has worked well
Okay.
in recognizing to sort of eliminate the step of having to ask the commission for leave to file something within 10 days. And we all recognize there's shortened time frames, so that procedure that Lyle's talking about has worked well.
Okay, great. Okay, Mr. Mush. Oh, you want to go first, Ms. Edwards?
Where I don't have much to add here.
No, I don't either. I do think you know, when this has come up, the commission staff has not been shy about shortening those time frames, asking for responses in a more abbreviated time frame. So I think that's worked well.
Okay.
On behalf of our clients, Jocelyn, we had no suggested changes or edits. We feel we've, you know, not had any issues and have followed it well.
Wonderful, wonderful. Okay. And everyone, I don't want to forget before we finish, because we're going to get in there shortly. I don't want to forget that. Okay, so now we move to the next topic. Mr. Terrain, how do you feel about the Commission Order 2024-352? And do we need a regulation for that? There's already a Commission Order about what has to be filed before the Commission will dispose of a motion for Pro Hoc Vici?
I mean, seems fine. The order seems sufficient to me. I don't know why you go through the trouble of a regulation, especially if somehow the court changes its Pro Hoc Vici procedures, which it's done before. You then would have to amend the regulation.
Yeah, which will take time. Okay, we just need to ask. We'll make sure. Mr. Richardson?
Same thoughts as well. Yeah.
Yeah, Charlie nailed it. I will say, if somebody's not following 404 SC ACR and not filing the motion, y'all should just reject the filing.
Oh, okay.
I mean, point of fact, if that's the complication. But the rules let the Supreme Court handle those because they can change them.
All right.
And one thing to add, I mean, I think the change in 404 tells, like, when you go to the website, it tells you what to do. So, I mean, if folks aren't following the rule or what it says on the website, then, I mean, they can move along or y'all can reject. But.
Okay.
I agree. The Rule 404 applies to all courts and tribunals in the state. And so, you know, I think rather than having to sort of catch up to changes by the Supreme Court to that appellate court rule or via order, I mean, for instance, now it's all virtual. You don't have to have those, you know, wet signatures and things like that anymore. So, you know, I think it would be problematic and unwieldy to sort of keep up with the changes. So let the court's rule stand. And I agree with Mr. Anselmo. If one of us doesn't do it right, to just reject it.
Okay. Thank you.
We have nothing to add.
Nothing, Mr. Mushroom, Mr. Edwards. Okay, last topic, everyone, is and I don't know how relevant this is anymore. You remember recently the Commission issued an order regarding our customer complaint process. I want to say that's in 83. And basically, when a complaint is filed with the Commission, staff issues the 30-day notice, and in that notice, we include the hearing examiner who is assigned to the docket. And then the hearing examiner has a limited amount of time to issue a report and recommendation, which is sent to the parties in the docket. And then the parties have a limited amount of time to respond before the matter is then given to the commissioners to make a decision. What was I going to tell you? Part of that order says that a hearing examiner, if need be, can schedule a hearing. And so I think where we were as it relates to hearing examiners and complaint cases is now narrowed under the Commission order setting the procedure for complaints. There is a special agent or examiner statute in the telephone.
I apologize for interrupting. couldn't hear the order number, the one that you're referring
The
to.
order number, hold on, let me
I
find it.
apologize.
No problem.
Ms. Boyd, I believe it's 2025-744.
740.
And
Thank
we
you.
actually ended up doing that in docket number 2025-191A.
What? Thank you. Under the Act 41. You're right. Thank you so much, Mr. Traywood. It is.
And
Did you get all
the
that, Ms. A?
procedures are actually in the attachment to the order, just in case folks are having trouble locating.
Yes. And Ms. Purvis, if you want to display that on the, because it's just the top part that I just referenced. The customer complaint procedures. And once a complaint is received, the clerk's office is just 30-day notice. The commission assigns the hearing examiner. And I think isn't that included at the bottom of the 30-day notice? Yeah. So the hearing examiner assignment is at the bottom of the 30-day notice. Then the respondent files an answer and any other information. And then the hearing examiner compiles a report and recommendation. The parties in the docket have 10 days to respond to the report. And there are a couple of days in the 10 days in receipt of the answer. That is for the hearing examiner. Once it receives the answer, has 10 days to file its report and recommendation, or the report and recommendation must be filed within 10 days of receipt of a hearing examiner directive, or within 15 days of the conclusion of the oral argument. I thought we had language. Yeah, this language is where I was referring to, where it says the hearing examiner may, but is not required to schedule a hearing examiner brief hearing if the hearing examiner thinks that he or she needs more information. So that's what the last item, that's what that is in reference to, everyone. As I said, with this new procedure, I don't know what the likelihood will be that the hearing examiner will convene a hearing examiner hearing. What I wanted your feedback on is the duties of the special agent or examiner that's mentioned in the telephone chapter 9, and also in the electrical utility chapter 27, is not in chapter 5. The special agent or examiner. It's not prohibited either in chapter 5. What are your thoughts, if you have any today, on promulgating a regulation that states that a hearing examiner, if needed, can hear cases basically to cover all of the commission's jurisdiction, from water, wastewater, gas, electric, telephone, transportation? That's my question. Mr. Tarani?
I like the procedure and the order, and I don't know if you need a regulation. I don't think you need to do anything new to allow the hearing examiner to serve in the water cases. I mean, you've got 103.804 says a hearing examiner is a member of the commission staff duly appointed and designated by the commission to serve as a presiding officer, et cetera, et cetera. And then you've got 103.841A says that when evidence is to be taken in a proceeding before the commission, any commissioner or any hearing examiner designated by the commission may preside at the hearing. So as long as the commission is taking the action on the evidence compiled by the hearing examiner, is there anything in the regs or in the statute that says you can't? I mean, I know 58.5.270 says if a complaint is not resolved to the satisfaction of the complainant may request a hearing before the commission. I think that hearing before the commission can be the commission reviewing the record that's been compiled by the hearing examiner. So the commission is merely empowering or employing the hearing examiner to take the evidence. So I don't see a problem there. In the alternative, as an experiment, you might just see, would people consent to that procedure, and that could resolve the issue. I suspect they might. It would probably be far less intimidating to a customer to present their evidence, not all customers, but most, to present their evidence in an more informal setting before a hearing examiner than it would be to appear in front of the commission. And from the commission's standpoint, I would think it would be a wise use of judicial resources. If the commission wants to have a regulation, we certainly don't object, but I don't know if you need it to start doing it right away.
Yes, sir. And thank you for bringing that up too about, because that would just be what we're looking at now potentially would be water, wastewater, and gas complaint cases.
Right.
So we'll just I'll make another big note should we receive that. And if the hearing examiner, Ms. Moser's in the room, if the hearing examiner thinks that the hearing examiner needs to schedule a hearing, we would just need to, I think, ask if there's an objection for water, wastewater, and gas, because the special agent examiner language is not included in Chapter 5. That's all we're saying. I think that's Mr. Richardson.
Yeah, I mean, speaking on behalf of, or with respect to Article 5, I mean, I agree with Mr. Torini. I'm not sure if we need a regulation if there's no specific prohibition against doing so. So would hate to promulgate something that might box us in the future or either just something that's already allowed. So
yeah. Mr. Anselmo, you have any comments?
About wastewater? I like opinions, but I don't have any on them. Generally, no. I think from the utility point of view, the process we went through to lead to the order was a good one. I think we'll see some benefit from that starting soon now that it's in effect. I've always thought that 103.804G dovetailed nicely with 5827.2030 that talks about special agent or the hearing examiner. It outlines the duties. I don't see the need for additional regulation on that issue at all.
Okay, thank you. Mr. Treywood?
Agreed. No comments with respect to water, wastewater, and gas, but like Mr. Anselmo, I would note that some of the more general provisions of 804 F talks about, what a hearing examiner can do. So does G for a hearing officer. And then, a presiding officer is defined in P, and then proceeding is defined in Q. And so all that sort of pieced together, I think, says what they can do right now. And so in terms of if you feel like there's a question regarding the scope of duties, I think it's answered there.
Thank you. Hey, none. Okay, thank you. Mr. Mustard, anything? Okay, wonderful. Okay, so everyone, thank you for participating today. Now we'll look for any follow-up comments that you have regarding our discussions today or any other thoughts that you may have. What I will tell you is, Ms. Purvis, will you display this page? I think what we will do though is ask for your participation. This is not reg related. It's more it's our public information. We may want to, it's possible that we want to make sure that this information on table 3 is still accurate and get feedback on that should the commissions decide to share this information with the public in any way. Okay? All right. Our next workshop is scheduled for Friday, March 6th at 9 o'clock. If you happen to be interested in the Commission's sewerage, utilities, and water utilities regulations.
Looking forward to it.
Good.
Charlie, have a good time at that one. Ms. Boyd, can I ask you a question about Article 8 real quick?
Yes, sir.
I think it's possible some of the parties might have proposed items to consider in other parts of Article 8 that maybe we didn't discuss today because you had put the topics out.
Well, and you can, I don't mean to interrupt you. Let's talk about it today. When do we want to schedule another workshop? This is what this is for.
I don't think my client is not prepared to do that today. We workshopped a few, but perhaps we could file written comments.
Okay.
And then to the extent you think we need another one, we can. I don't want to belabor it today because, again, I'm not ready to present them today.
Okay.
But if that's okay, we'll just file some comments on the other ones.
Yes. Can we talk about a time frame, everybody? Because things will get away from us over here. Is that okay?
Sorry, everybody.
We took I'm gonna be honest with you. We thought everybody wasn't interested in filing comments because we took that statement, filing comments, that there weren't going to be any comments.
Well, if the commission
But no,
doesn't
we
want
want
any,
the comments.
that's fine.
No, we want the comments. I'm saying we thought that nobody has any comments on Article 8.
I think it was a function of timing on that when the notice came out
Yeah.
on topics versus the comment deadline.
Yes. So, what did I say? Our next one is on March the 6th. Is March 13th long enough? I don't know where you are, everyone, on compiling any other comments you may have. Is that long enough? Okay. It's Thursday.
Yeah,
Mm-hmm.
that's fine.
Okay. Well, we look forward to it. And Mr. Anselmo, I can't promise you there won't be another workshop after that.
Hey, you know, I love a workshop.
You know.
As long as they're Friday early morning, you know, especially as the weather warms up. I think
it will be warmer. So, so we'll look for any comments that you make that we didn't talk about today. Please file them, seriously, please. Thank you so much. I know we will be seeing most, if not all of you, very soon in some form of a public hearing or something. Have a great weekend. Thank you.